Sorry. Well, good afternoon. I don't know if I read the instructions closely enough to know that we were going to accomplish everything that was just said. But we will have we'll have a conversation that will touch on some of that. I'm sure all of you know, either know or know by reputation, Judge Nguyen. He's on the Fourth Circuit Court of Appeals. He was on the North Carolina Supreme Court, on the North Carolina Court of Appeals. He was in private practice in Wilson, North Carolina. He was in the military, both as a lawyer and a judge. And I don't think we could have found anybody with such a broad range of experience who has seen the issues that we're discussing today from so many different perspectives. I'm not going to, we don't have enough time for me to give you the introduction that's warranted by all that he's done, so I'm going to stop there and get right into it. Thank you for coming to Duke. I know you're a Carolina guy. So what I'd like to do first is to play a clip of comments that Judge Nguyen made at an oral argument in a case that our clinic here did in the Fourth Circuit. We lost the panel decision 2-1. We filed for rehearing en banc. The court granted it. And we argued it. The case involved Ronnie Long, who was convicted in 1976 of rape. He was innocent. The police hid evidence, lost evidence, lied on the stand. The prosecutor lied on the stand. And yet the state of North Carolina continued to defend the conviction. And then finally we got to the federal court in a habeas action. We lost in the district court, lost in the Court of Appeals on procedural issues. We couldn't get any of the judges to look at the facts until we finally got to the rehearing en banc. And I'm going to play a short clip of the remarks that Judge Nguyen made, and then I'm going to ask them about it.
Judge Nguyen has a question.
I just wanted to follow up somewhat on Judge Mott's question and the answers that you give in terms of the evidence. You've indicated on several occasions, particularly with regard to the detective, you didn't say it was false or dishonest. You said, well, he was mistaken or inaccurate. When the prosecutor argued at the end, you didn't say, oh, that was not right, it was inaccurate. And I wonder, in light of Judge Mott's question, which I think goes deeper than just the practice, the procedural practice of what happened in court. We're talking about the realities of circumstance 44 years ago in North Carolina, in Concord, North Carolina, which I've lived all my life. We're talking about the reality of many types of prosecutions and circumstances in which law enforcement did certain things that were certainly not, they were a little bit more inaccurate. They were deliberate in what they were doing. And here the zeal to prosecute 44 years ago with evidence that clearly, even then, should have been disclosed. And the question then becomes up as to materiality. Well, we've got so much other stuff here. Maybe then we're going to excuse this sort of conduct. And I understand that we cannot put ourselves back in 1976, in 2020. But the reality is when we apply 2020 arguments to evaluate what happened with a jury in 1976 under these circumstances, we go back to Judge Motz's question of how do we view 1976 and the realities that we are not being so forthwith in discussing here today, because we just don't discuss things like there were black men who were being prosecuted wrongfully, and we know in great numbers. There had been lynchings far beyond then, and it was not over in 1976. It was continual. And yet you have evidence here that prosecutors had evidence that clearly any defense counsel in the world, not only in 1976, but since the history of this country, would have wanted or needed and should have been supplied, as later indicated by Brady. And yet they did not provide it. And then to get on a stand and make statements that are patently false, characterize them as inaccurate as you want, they were just patently false statements, coupled with as you say, the totality of the circumstances in dealing with that era. And that's the element of concern we're talking about when we say 44 years ago. And then I'll end with one last thing. When we look at these cases, I often wonder, why is there such zeal not to look at evidence and make that determination now? What is it about us that want to prosecute and keep people in jail when we know evidence may exist that might lead to a different conclusion? Why is that so offensive to us now that we want to go and protect activity that happened 44 years ago, and it may come out to the same result? But what is the harm? And in the end result, he spent 44 years in jail, even if he was to get out. That's a significant punishment. So when we look at these circumstances, I just don't understand why we wouldn't take a look at it. And what is the problem with having more discovery? And particularly when we know, like the fingerprint information here, as you say, that is latent evidence that ought to be considered. We didn't have, and by the way, I think there was some semen. Somehow it disappears. Did it not? I don't know if it ever came up, but there's evidence it was in the police's custody. The semen, which you didn't have DNA back then, but you surely did have tests that could have led to an exoneration if certain tests from that had indicated such, or at least strong evidence that he did not do it. And yet it disappears. But we, in 2020, we sit here with our own pre-notions of how evidence should be viewed, and we said, well, we're going to just give it the benefit of the doubt in 2020. But we know what happened in 1976. I mean, it's very difficult for the conscience to even accept that as an argument when it's so simple. All we're saying is just look at the evidence. No one's making a determination today. Just look at it. What's the problem with that?
When we had the argument in the case, it was a virtual argument, so we were on Zoom, and we couldn't see the reactions of the judges or the counsel for the state of North Carolina. But the impression that we had as you were talking was that you weren't just talking to the lawyer for the state of North Carolina, you were talking to your colleagues, and you were talking to the state of North Carolina. And I wondered, was that your goal? And why did you want to do that?
Well, thank you again for letting me be a part of this program. And nothing I'd like to do on a Saturday afternoon when the Duke game is on. My favorite team, Marquette, is playing the #1 team right now. And having just spent a week on the beach at Outer Banks and driven back, I looked at my wife and says, only for Jim Coleman would I do that. But it is a delight. Let me just set the stage for what just happened there. First of all, I had no clue it would be recorded and be presented all around. But I will say that's not the normal length of what you will call a question. But you need to understand the Fourth Circuit. And I say this forthright because there are certain things that go on the Fourth Circuit, and you need to adapt to it or sit back and let it just happen. I'm not the only one that asked a question like that. There are several justices, the judges, they don't just ask the question. Oh, they give a narrative. And that's what we had narratives all over the place. Well, we're looking at the evidence here and we give it the benefit of the doubt. And my purpose here was to say, you're going to get that say today, but there's another say that's going to happen in this court today. And I'm not going to be rushed in giving it because it was an abomination. It was offensive. Ronnie Long unquestionably was innocent. The evidence that was not being allowed would have indicated that. It was certainly it would lead almost conclusively to the fact he did not do it. And ultimately it's determined he did not do it. And he spent 44 years in jail. And yet we get in these instances, and this is not the only case I've seen this, in which you have exonerating evidence, or at least evidence that should have been put in, and the court, which is a court of justice, has a reluctance to look at it. Why? It still baffles me. To protect the reputation of the prosecutors or the reputation of the judge, or to protect the institution of the jury in terms of, well, the jury reached a verdict and the evidence that was before it was legally correct. Perhaps it was, but are we not interested in whether it is factually correct? And when you have information there that indicated that, that was a point that really drove home, and it probably drove home. I don't make it any, and we'll probably talk about this more so when we talk about decision making. Every judge comes to the court with some type of a background. One of my favorite quotes from perhaps an unlikely source, he would probably roll over in his grave if he knew I use it in this manner. But Justice Scalia had a quote in the Minnesota versus White case, which was the Republican Party of Minnesota versus White. It was a speech case dealing with judicial speech. And I love that quote. He said, "Judges do not come to the court with a tabula rasa." And I said, thank you, Justice Scalia. What you just made is a case for diversity. Because if you come with different experiences, why not bring those experiences to bear on the decision-making process to allow a more informed decision? And I know my background, and there's a particular judge on the court, he and I go at it all the time. I absolutely enjoy this because it's amazing to me he respects my opinion because he's so scholarly, and we go at it all the time. And he said to me many times, he'll say, well, Jim, I know I come from a different background. I grew up with a silver spoon in my mouth. How many people go and say that? But it was true. I mean, it's undeniable he did, but he acknowledged it, and that's part of the process. He knew that I did not grow up in a situation like that. And while I think I can give a different perspective, it's not the only perspective, but I wanted that to be on the table. Decide as you wish, but do not decide it in the dark. You would decide it with all of the information, and that was the moment to have my say. But I didn't know it was going that long, and I surely didn't know you were going to play it here today.
But we were very happy to spend the time listening to it. It was music to our ears. So you talked about the realities of 1976 in Concord. And I wonder, what did you have in mind, and what from your own experience informed your question in 2020?
Well, some of the things that you probably could take judicial notice of. There was a very active Ku Klux Klan there in Concord at the time. They were behind this prosecution the whole way, and we knew this. All of this evidence was there. It was clear this whole incident, the evidence just was not there to support it. And yet, the reality is in 1976, and maybe to some extent it exists today, but certainly not as blatantly, it was pretty open racism and decisions to make that would impact lives of those who were not in a position to defend themselves well, or who were not exactly looked in the community as being people that want to be protected. So, that's probably a general way of putting it, but 1976, the courts were very different than what they are today, particularly for those who were of color, and particularly in the South.
And for the most part, I mean, if you're not on the bench and talking about those things, they don't come up in the case, and we get a very different outcome. What's your reaction of your colleagues when you sort of put cases in context in that way?
I will say, one thing I can say for the Fourth Circuit, and I see it all over the country, we are perhaps, I would think, one of the most collegial courts in the country. And the level of respect for opinions is amazing. Now, can we be sharp and caustic and really go after, just read the opinion, it's pretty much there. But nonetheless, I have enjoyed it and continue to enjoy just the respect of different views. After all, I've heard the earlier discussion about Chief Justice and judges. The reality is that same Senate that confirmed the Chief Justice confirmed me, and I'm here for life. I don't go anywhere until I choose, and some of you know I've chosen, but I don't have to. It's the only profession I know when you hit 70 years old, people ask, why are you retiring? But I think that's the big difference. I think that's the big difference when you're dealing with colleagues. And by the way, you might not like some of the judges who are selected in the federal process, but in my opinion, they are absolutely brilliant. May not be your temperament, might not go in your direction, but in terms of their education, in terms of their scholarship, their ability, they're absolutely brilliant. And then the other factor, Anita, I see you sitting there, but I want you to hear this. But from a state court, I spent nearly 20 years on a state court. I never saw the type of law clerks that apply to me as a circuit judge. 500-600 applications per year. And ultimately, I see them, looks like to me, that didn't make anything but an A for the time they breathed air. And they're just absolutely top, the most mature individuals I've ever seen. I am not a stickler for looking over shoulders. I don't demand they stay beyond 5 o'clock, but it is pretty much likely right now at 3:50, I could call that office and one of those clerks would answer. And I didn't tell them to go there and work today. But that level of commitment is something I ask for. They have one job. You know what it is? To make the judge look good. That's all the job is. But part of that is, as with anything, to take ownership of the product that comes from here. To take it as yours and because it will follow you the rest of your life.
I'm going to come back to the Long case in a second, but I just want to ask you, because you brought up law clerks. Diversity has been really important to you in the selection of your clerks, your interns, externs, and so forth. The time that you were in the Navy, you also said that you ensure that young officers got the medals, promotions, and leadership opportunities they deserved, and you call that creating force multipliers. What do you mean by that, and what's involved in trying to do that, and why do you care?
It's one of my favorite terms, force multiplication. It's a military term, and you can easily see how that fits in, where you have maybe the Air Force, the Army, the Navy all working in conjunction, different forces, and when they get together, collectively, the forces multiply. And that goes, too, with the work that we do in my chambers with clerks, and I make it clear to them we do not have competition within there, because I told you there's only one job in there, and I'm it. And they accept it readily. I probably apply it more in the religious arena than I do in the legal arena, because I see force multiplication for the Lord doing different things. But it's a term that I think means to collectively bring together different forces. And by doing so, it is the result is greater than the sum of the parts.
And I take it that you also believe that it improves, well, obviously improves your work, but also the court's work to have these diverse law clerks and interns and externs. I mean, is that true?
That is true. And let me add something to that. My friend Shirley Ifield, I won't get myself in trouble because I tell you I'm already leaving, so I guess I can say what I need to say, but I do it anyway. When you think of diversity, you are thinking in terms of Shirley Ifield, who's a professor, a friend of mine. She says that there's representative diversity, and that's just by virtue of the way you look. You just sitting on a bench. You look like Jim, me. And it says, oh, it's diverse. Well, that's representative diversity. And then there's substantive diversity. And that type of diversity brings to bear a different experience on the court. Doesn't seek to simply conform or to try to mock the existing culture, but lets you know there's another perspective in it, and does so in a way that represents greater than just physical representation. And I won't give you any examples of that, but I think some of you probably have some good ideas of what I'm talking about, the difference. But I did not go there. But so I think, to the law itself is a powerful vehicle. If there's one man on planet Earth that I just admire his work, was Charles Hamilton Houston. I've written on him. And how he took this doctrine of stare decisis and marshaled a line of cases that led 20, 25, 30 years before it was argued to Brown, from Gaines versus Missouri to Sweat versus Painter, different aspects, building that ladder that when he finally got to the Supreme Court, that Supreme Court was locked, I'm telling you. When you say that equal pay for teachers has to exist, you got to let graduates, it was locked. But he knew better that you could not start with the elementary kids and the kids first. It just wasn't going to happen in that way. So my point is, and I had a wonderful professor when I was working on the master's at UVA, and he would start every class and he'd say, and I wondered, but I got it. He says, what is law and where does it come from? And you think about the things that have happened in history, it's because the law permitted them to do so. Why is it that sheriffs were able to do the sort of things they did? They took the law and used the law to do things that were corrupt at times. Or why do you have individuals who were successful at doing it? Why did you even have slavery in this country? It was the law. There was nothing illegal about it at all. And so it's the law. When you focus on the law, you can change behavior. If you focus, and I didn't invent that. I mean, that comes from Von Ewan from early. He took it to Roscoe Pound. That's how Hamilton Houston got it and went to Thurgood. They call it sociological engineering, but it really comes down to the law governs pattern. I'll give you the most simplistic example when I give speeches. I said, if you don't think I'm telling you the truth, you're not born stopping at a red light and a green light. You're not. You learn that's the law. And you obey it. Everybody in here would obey it instinctively. And you can see if you change law, which is I want to make one last point, because I've been giving speeches on this for years and people don't get it yet. And they really don't. I mean, because it ties in with this and they say it's kind of off, but the point I make with James Williams, when I try to get them to understand, look at the 13th Amendment for the end of slavery, not Juneteenth. I don't have anything wrong with Juneteenth. Nothing happened on Juneteenth. Nothing legally happened. In fact, it was an abomination where the general comes in and tell slaves who already have something for the Emancipation Proclamation, you're free, but he said, go back to work and do these things, do we not be protected? There's nothing happened on that date. The reason as a lawyer and as a judge I focus on the Constitution, because the Constitution changes stuff. When you change the Constitution of the United States, says slavery is abolished, it happens. And it may take time, but it becomes the law. And I want us to focus not so much on trying to change policy or opinions of how people feel. Change the law and you will shape behavior. And that's clear in my mind. 30 years ago, you couldn't have got me to bet any amount of money that same-sex marriage would be the law in this land. Guess what? It is. And it happened because the law changed. It didn't happen because policy or whatever. The law changed.
Now, I'm going to return to the Long case. In your concurrent opinion, you argued that the case should not be remanded. You should grant relief. You thought he was innocent. You thought no reasonable juror would vote to convict him, but the court remanded anyway. But did you follow up what happened on remand?
I think the governor took care of on remands.
Yeah, a lot of them. The governor, the attorney general,
Right, so, we expected that we were going to be litigating, under the ADEPA, and the state immediately threw in the towel, admitted that the conviction had violated the Constitution, vacated the conviction, threw out the charge. The governor granted a pardon of innocence. He succeeded in a civil case, and then, probably most extraordinary, the city of Concord made an apology to him that was unequivocal and I think sincere. And I say that, and I point out what happened because I think what you said in the argument told people that ultimately the result was going to be this man is going to be free, so why drag it out? Right? And I think that's the kind of, I think that's the kind of results that happens when judges are willing to speak out and draw people's attention to what the facts are and not sort of the procedural issues that you can continue to litigate.
Well, there were other judges who joined me in my concurrence on that. And I think when it comes down to it, the reality for those of you who served as judges tend to look for ways in which to, well, let's send it back and let someone else kind of go through it and look at the evidence and give the trial court the first shot. But here's an instance where the evidence was manifest. It was right there in front of us. It had been 44 years. He's still in jail. And we know this man should not be in jail. And, I guess in the world of judges, there comes a time when enough is enough. And you can only, one of my favorite lines from Tombstone movie, you look at it sometime, Doc Holliday he says, my hypocrisy only goes so far. And I was pushed to that.
You grew up on a farm in North Carolina, and today you end up as one of the most prominent federal judges in the country. How did you get from there to here? Why did you decide to become a lawyer, and who influenced you?
There's a canned answer I could give you, but when individuals ask me, so Judge, how can I get to the Fourth Circuit? I said, well, you can't do it the way I did it. Because each path is unique in the way it goes there. I didn't start out with the idea of being a judge, as probably most people in this room didn't start out, no matter what color, you probably didn't start out being a judge. Sometimes if your dad is a judge, you can kind of think about it, but most of us didn't have that connectivity. It was a series of events, choice of going to school at UNC, then went to Marquette Law School, and which was not supposed to happen. I actually was going to New York, but I went to Marquette because it opened a week early, and I'd just never been. I thought I'd go see, and the dean asked me to stay. He said if I stay a year, he'd get me in anywhere, and I did. It ended up being 3 years. I then went into a place none of my classmates thought I would go, into the Navy, because I went to law school with one purpose, because I was broke, and I wanted to make money. If I could help people along the way, that was good. But I really wanted to make money. All my clerks now want to be social people. They want to help everybody. I tell them, I went to school to be money. Those kinds of decisions proved to be incredible. I mean, my son who went to Harvard Law, I often tell him, I says, well, you went to Harvard Law, but it'll be a long time before your portrait's going to hang up at your law school. And you'll get the top awards from the school. And I sit on the board of trustees there, and the same thing with the Navy. I was able to stay in the Navy ultimately a total of 30 years. I did 4 years active and 26 years reserves, and retired as a Navy captain. I was a military judge for a long time and really tried cases from the Philippines all over to Naples and everywhere you could think of. And those experiences have come to bear, as I say, you don't come here with a Talabrasa, but you are the sum of those people that you used to be. We're all part of what we've been. We bring those experiences to bear. And then I went in practice. It was just happenstance. There was no plan for me to join G.K. Butterfield and Toby Fitch in the practice of law down in Wilson. I was going down there to practice myself, and fortuitous for me, G.K. Butterfield thought Rufus Edmondson was going to be the governor, so he had taken off to go take care of Rufus. And he gave me his practice while he was gone. And then he came back, and it was, I will tell you, that was one of the more marvelous experiences. We developed a saying in the firm that we never charged a fee that was not divisible by 3. And to this day, we carry that on and that connectivity. And who knew that relationship would lead to so many type of opportunities? First, going to the State Court of Appeals. I did not have an interest, believe it or not, of going to the State Court of Appeals initially. I had argued some cases at the Supreme Court in North Carolina. I've been in the Court of Appeals when I was at the Appellate Defender's Office. And I was practicing law down in Wilson and Greenville and kind of felt like I was doing pretty good. And it certainly was a little better than what they were paying the Court of Appeals judges. And, but then my partners prevailed on me to run in a statewide election. I didn't think there was a chance in the world I could win that election because I didn't know people all over the state. But then I found out, you know, if you want to win an election on a statewide here, you better belong to a political party because they are the most powerful political engine in the state. So either Republican or Democrat, you need to be one of them. And I don't care how nonpartisan you make it, that's the only way. With no money, you can't run a statewide race. And any judge who is on these courts who thinks that you are well known, I think I won 5 elections statewide. I can walk down Fayetteville Street and no one would know me the day after the election. No kidding. I mean, it was amazing. And so you get this idea, I won the election. Yeah, you did, but someone else won it for you because you're connected with people and you're connected in the work. My big connection, I can say it pretty openly, I was pretty forceful in writing opinions straight from on the State Court of Appeals. I wrote a lot of dissents. In fact, the Supreme Court wrote 8 times within the first 2-3 years for reasons stated in Judge Wynn's dissent, we reversed. I started getting a little respect. And the Academy of Trial Lawyers gave me awards and stuff. And those guys got money. And they were helping me in the election. So ended up I was unopposed. And that's where the legal career took off and spent only a short time on the state Supreme Court. But I tell my friends, I said, I tell you what, I was only there 3 months. But I wrote a case there. I guarantee you every law school is teaching that Nelson versus Freeman case right now that abolished the distinction between licensee and invitee is still being taught in the school. They often said, well, what would have happened if Judge Wynn had won an 8-year term on that daggum court? But again, need apologies, but I don't know of a judge that has come, a justice that has come from the state Supreme Court or Court of Appeals to the Fourth Circuit other than me. It just typically does not happen, Republican or Democrat. And so here's that religious coming back out. The Lord put me back on the State Court of Appeals for a reason. And I stayed there, and G.K. Butterfield decided to be the only one to endorse Barack Obama for a reason when nobody else was doing it. And things took off from there.
So you've had a lot of experiences as a lawyer, as a military lawyer, as a judge, federal court, state court. What's been the nature of the bias and disrespect and discrimination that you've seen, and how has it changed over the years?
Well, I think, in the state of North Carolina, because when I came to the court in the 1990s, the respect in the Democratic Party for that black vote was high. And so you inherently gain respect once they open up the opportunities. Cases of Jingles and others began to give opportunity for black voters to go to the polls. There was a serious perception. For instance, so one of the reasons I ran unopposed, as is Cliff Johnson and Henry Fry, it was perception. You won't run anybody against one of those guys, you're going to just excite the black vote. And perhaps that was a good perception. I think they found out that's probably not necessarily so. So things have changed in terms of how we do things, and since the time we've gone on.
Are there memorable moments and experiences that you had that shaped your current view about speaking out on these kinds of issues?
I've met some very courageous judges in my time across the country. from different courts. One of the things I did is I became just enormously involved in a lot of outside educational opportunities. And I met judges from all around the world, literally, to some extent, but particularly in the United States. And they are powerful, strong judges who stand up for what's right. And they do so with courage. And I'm also a student of writing. I majored in journalism at UNC, which is one of the reasons I have so much fun with a few of my colleagues on the court. They're just incredible writers. And I just love, mimicking it and giving it back in a legal way without using the language that you would like to use. You do it in the same certain way. And it has the force of change when you do it that way. So that's.
So today, we're experiencing what seems to be a backlash. People are openly and aggressively attacking judges and lawyers, and a lot of the attacks have been aimed at women, and particularly Black women who have been who are prosecutors in big cases and judges in big cases. What's your perception of what's going on?
Well, I have great hope because I tend to think that even the bad judges, Justice Hudson may disagree with me, if you keep them on the court long enough and they begin to have to write their opinions and they begin subjected to what actually they have to defend them, that ultimately perhaps they change to some degree, or at least you get them to conform. But quite candidly, what's going on now, it's driven from the top. I mean, that's when the king didn't have any clothes on, no one would say it. No one's saying the king has no clothes on. This thing is being driven from the top. If you got a particular individual of that level of power that just thumbs his or her nose at a court and just totally disrespects judges, disrespects the process, what do you think people do? They do the same kind of thing. I mean, that may be why you get a rush on the Capitol. You think you can do it. And again, is that law? You think the law will allow you to do it. So the openness of the courts, and I think I think the tide is changing because I think the judges are beginning to realize a truth that has long been the case. There's no such thing as criticizing a particular judge. It criticizes the system. I don't care who it is. If you pick a judge out and you just constantly on them, saying they're terrible, terrible, ultimately it would be the system is a problem. And we are the guardians of that. So what we do is we use our opinions, we use our concurrences, our dissents to bring forth issues in a legal way, keeping it relevant to the topic. And we try to advance it from the court. But we also try to become models for other judges. And it's amazing that, as I said, the collegiality is high. We don't get those kind of interruptions on the court from the full circuit. If you are talking, did you hear anyone interrupt me that whole time? Not one soul would do it. You could probably talk all day. They would not do it. And then I would never interrupt them. And you try to keep the personal side out of it as much as you can. So I think the pendulum only swings so far, my friend. And this is a bad time. But it's bad because of what's happening at the top. It is empowering, giving people a sense of empowerment to do it, to stand up and to say things out of character in the court, to actively challenge and talk back to judges and say things that way. But I mean, if that was the case, we never would have gotten with Bush versus Gore. I think Bush versus Gore is one of the most important cases in my mind in terms of the system, not for the result, but the fact that once it was issued, you just respected it. You didn't like it. Some people hated it, but they went on about their business. The court kept going. And I think ultimately that's the way the judiciary needs to work. And I think that's the only way to keep it going, which is why you've got Chief Justice Roberts going out of his way, trying to keep this judiciary intact and keep the judges focused. Because, ultimately, now there's another element when you vet judges who are already in a particular view and they cannot be moved, that's a difficult situation. On either side, it's a difficult situation. And I hope that in time, that too will prove to be, a passing thing.
Is there any difference in the freedom that you have as a federal judge to speak out about issues like bias and inequality, and a North Carolina state judge, sort of based on your experience?
I would have been thrown off to the court for the things I would have said. I think you not only I think you have a duty to speak to bias. The role of a judge is to improve the judicial system. And if you see something in that system that is not good, you have a duty to speak out. You are elected not to just to follow a role and step in line with what other wants or to make them look good. There is such a thing as bias. There's such a thing as racism. And unfortunately, a lot of it is implicit. A lot of it is not as forthcoming. But individually, and I often use this phrase when I'm talking to my colleagues at times, I will bring things to their attention. I said, let me tell you why I'm bringing this to your attention. Because I want you to hear it from me. I care about you. I don't want you to wait and hear it in the broader public and says, well, why didn't Judge Wynn say something to me? He should have known this thing. So I think, individuals, regardless of where you come from, if you can add, and you genuinely believe it serves to improve the judiciary, to me, the canon squarely allows that. And whether you get your feelings hurt or someone else feels like they're not a part of it, the answer to that is, well, let's dialogue and let's see, can we change this if either we disagree or we agree on certain things and make it better. So I do think a judge has a duty. When you write an opinion, you pretty much got a blank slate what you can say in it. Maybe if you get up in the forum, there may be some that say you can't say it. But the kind of stuff that I've written in opinions is I get that point across, just like you're in that argument right there. That's the same thing. I'm on the court. Who's gonna challenge me for what I say on that court right there? You can challenge all you want. But I haven't seen a judge get impeached for the kind of stuff I said there. If it did, we'd have nobody on our court. I guarantee you that.
Not a federal judge, but what about a state court judge who's elected? Does that diminish the responsibility that the judge has to speak out, or?
Probably enhances the responsibility because they are elected. That was the whole Jacksonian principle, was we don't want a group of people appointing judges. We want the people to appoint. So to some extent, a judge who's elected on a statewide basis they owe the people. That's a direct link. The same statewide voters elected a governor. There are more people it takes to elect a justice or a judge on the state court of appeals than a congressman. You know that, don't you? Because they're in districts. So when you think about it, you represent the whole state of North Carolina, not just this section or that section, but you have a duty to speak up, in my view. And as I said, I've been pretty outspoken during my career, and I guess no one's ever brought it up in my vein, but probably would have been fun.
Is there anything that federal judges can do to basically have the backs of state court judges who speak out and then get attacked?
Well, I think to some extent, you must restrain yourself from getting involved in issues that may have some effect, but at the same time, it could lead to a greater and broader attack on something. And so from the federal judge perspective, quite frankly, I think I was telling someone, I was telling you, I was coming in, I spent 20 years on the state court of appeals in the Supreme Court. This job of being a federal judge is pretty monastic. When I drive into my office and go to that office, I'm there all day long. Maybe if I take lunch, I'm literally all day long until I drive home. And I don't know what it is with federal judges, but lawyers do not walk into an office of a federal judge. It just doesn't happen. No one has ever in the 13 years knocked on that door and says, I just want to talk to Judge Wynn. Doesn't happen. Of course, it helps, I guess, when I got a JA there on the door and you got to go through a buzzer system and the whole bit. But it's a pretty monastic job. And in turns, there are a lot of things that you want to get involved in. My choice is to get involved in the decision-making process, to look at the evidence. And if it's there, then in the opinion, I think you make more of an impact in the opinions, because that's law. Didn't I tell you the law changes stuff? You can write I wrote articles for the Washington Post article that got all kinds of press. Qualified immunity. Well, they gave it to me. I mean, it was there. They were talking all over it, and I did the same thing. But the fact of the matter is, it's just an opinion. And it may have some short-term effect. But the real effect comes when you move the law, and whether it's in case law or legislative law, or however. So, when it comes to matters of that, the other thing is, it's not a good idea for me to get involved in any other activity like that, because that leads to a recusal. And what good will I be to you if I'm recused from every time something comes up and I'm jumping into a fray of that sort? So, for the most part, federal judges do not do that. We have a lot of things to do. And if there are changes that will happen, and when I say changes, it's not an active change. It's not a foregone conclusion what's going to happen. But the idea is, by looking at the evidence in a balanced way, if it's there, you can speak forcefully then. You can write it. And the beautiful thing about writing an opinion is the law, and the stare decisis means it will last, and you can build upon it. Opinions and newspaper, things like that, they have some effect, but it's not. Even speeches, what I'm talking to you today, has some marginal effect. But by tomorrow morning, most of you be eating toast and eggs and forgot most of what I said. If I wrote an opinion, you probably might read it a week or two from now.
Let's talk about incidents of disrespect that happen in the courtroom toward lawyers and their clients, toward judges, toward each other. I mean, how do you deal with those kinds of things?
I probably have called upon my military background. There's one particular instance I was on the state court of appeals. I probably haven't talked about it in a while. And it was a case in which it was a criminal case, and the government, represented by the Attorney General, had one side of, and the lawyer from the Attorney General's office was late. And I think it's because of the fact that our cases move real quickly. And so I was presiding. I started the case. I said, go ahead and start your case. Well, he comes in the courtroom late and then slams his briefcase down and walks up. And I stopped the court. And I called him, just like I was in the military. I said, I want you to come to this bench right now. He stands right. I said, now I am just a few minutes from calling down to that officer to get you out of my courtroom and never to see you again, unless you turn around and apologize to everybody in this courtroom. He's a nice guy. And of course, he recognized, that's a tough situation. I had the support of my colleagues, I guess, but it didn't matter. I was presiding over it. I think when instances of disrespect occur in the court, you have to keep in mind it's not personal. You are there to protect this courtroom and the fealty of those who are here, whether it's lawyers, the respect. When you let it start, what did Barney Fife used to say, you got to nip it in the bud, right from the beginning. So if you got to take command, and I don't mean being a dictator or a bully. There's a difference between them. There are instances, you don't do what I just did every day. Most of the time you're smiling and you're going around, everything's good. But when it happens, then you go there and let them know this is a court of law. And this is what, and it's even in the state court, every court I've seen, lawyers get it. They get it, and they should get it, because there's a state bar out there that probably likes to hear that sort of stuff. And we probably, on the state court of appeals, maybe one or two times did refer someone to the state bar. That's not a good thing, but I've not done it on the federal court. We don't get that.
And what have I run out of time?
The ball game is almost over, man.
Okay, I'll wrap it up then. You see, you get caught up in this, and it's all very important. I really appreciate you coming in and sharing your thoughts with us. We're going to miss you on the bench, in active cases, regularly on the bench, but I hope you keep up your voice and keep speaking out on these kinds of issues. It's really important.
Well, thank you, Jim, and thank all of you for being here.